This was the system prevailing in. Then why the partition, the concept of partition came into? If you carefully look into the political and economic history of the country, again, for the first time in our country, the industrialization was introduced. In 1780 or 60, it was introduced in England. Because we were under the British yoke, it was introduced in our country around 1840 or so. Cotton mills were developed in Maharashtra, Gujarat, etc. And thereafter other industries also came. Industrial output increased, townships increased, and hitherto what items were produced by the manual labor, by the rural artisans, all those implements were produced, all those goods were produced by the industries. And therefore, the village, particularly the rural economies, suffered a lot because they lost their regular works. Ultimately, they had to migrate to the towns in fetch of their jobs, which necessitated a mass exodus into the towns, leaving the villages. This was the situation around 90s and early part of 2000. And this also had a drastic effect, adverse effect on not only losing the jobs, but also slowly but steadily and constantly withering of the joint families. Joint family had to suffer a setback because most of the family members, all the males, young persons used to migrate to the towns, and therefore slowly the joint family system withered and division became order of the day in every second family which were living in the rural areas. That is how the partition system has come, the historians and commentators would say. When the partition was practiced, at that time there was no a statute governing the partition, how the partition has to take, what are the principles to be followed. We didn't have any statute, isn't it? Obviously, the people used to rely upon the customs, usages, other practices, and most importantly the principles and guidances given in the spiritual texts by the hermits like Narada, Parashara, Agnivalka, Jimutvahana, who were the religious hermits, not only giving the text on the dharma, but also artha, kama, moksha, all these aspects, and family aspects governing the marriage, adoption, and division of the properties. Most importantly, they laid down certain principles. Those principles in the form of customs being followed by the people. This was the early stage. If you read the commentaries, you will understand it. The most important aspects or the most important or prominent schools of thought with regard to the partition is concerned, we have had two important schools, isn't it? One is
Mitakshara school and Dayabhaga school.
Very good. Mitakshara school of law. Please take it. It is not a lecture oriented session. It is a mutual confabulation. You can intervene and you can give your own inputs wherever we fault, or rather I falter. We readily accept and learn it. As our friend stated, two prominent schools were prevailing, Mitakshara and Dayabhaga, in all other aspects, but most importantly on the partition of the properties. What is the Mitakshara school of law? What it prominently, or what are the characteristic features of the Mitakshara school with regard to the partition? And most importantly, which areas it was prevailed?
Except Bengal and Assam, whole of the India practiced Mitakshara schools.
Very good. Except the states of Bengal or provinces at that time, Bengal and Assam, the other areas, or we can call it the rest of the country mostly, the Mitakshara school of law was prevailing. It preached or it proponed some important aspects related to the partition. The first and foremost is co-personary. Is not it?
Yes.
The co-personary is nothing but a family, or likely you can take it a joint family, which is a larger concept including all the blood relations, both women and men, from out of which a smaller circle can be drawn in the form of co-personal, means only those male persons who are downwards from the common propositors or common ancestor up to fourth generation. Suppose if a person is there A, for your easy comprehension, A son B, B son C, C son D, up to fourth generation of the males used to constitute under the co-personary, and they were called as co-personers. And what is the right that they have? They have a right in the co-personary property which they have inherited from their ancestors, or which by virtue of their exertions they earned as individual property, thrown into the common hodgepodge or blended into the common hodgepodge. So the co-personary consisting of the male members predominantly up to the fourth generation from the common propositors, and they have by virtue of their birth in the family have a right in the co-personary property. This is what one of the main features. The second one is, obviously when the male members constitute co-personary, it needless to say that women were not given any right. They will be only joint family members but not co-personers. The third characteristic feature is they used to enjoy jointly till a partition takes place, even the male members. Till a partition takes place, no male member, no co-personer can proclaim that I have a definite share in the property, is not it? It is a common enjoyment at that time till the partition takes place. This is one of the aspects. But they can demand partition. And when partition takes place, their shares will be defined depending upon the number of the male members available as co-personers. Another important feature is with the births and deaths of in the family, mostly males, the shares used to fluctuate. Is not it? One more male member, the share of another person will be down. With the death, it will increase like that. Of all, another important feature is the existence of survivorship. Right of survivorship was another important feature. Means, if a male co-personer died intestate, leaving an interest in the co-personary, his right in that undivided share will devolve upon other living co-personers, usually males, but not on what we now call as class 1 heirs, comprising the women also. That was the situation prior to 1956. If you see this system, we can easily understand that women as a wife or a daughter or a sister, whatever name you may assign, she was not given anything. Then what the women folk as a members of the joint family used to get, they had the right of marriage. They had, if any widows are there in the joint family, they had the right of maintenance. And of course, during the course of marriage, some families as a tradition used to give some property, what we colloquially call as Pasupu Kunkuma, isn't it? Pasupu Kunkuma gift used to be given. You might have seen as an advocate, you might have come across, one document would be written as a Pasupu Kunduma gift deed, whether that gift deed, as under one section 122 of TP Act, requires registration and stamp duty or not. This controversy went on and ultimately set a trust by the Supreme Court that though it's a traditional form of gift, it requires stamp duty and penalty. It would be excisable to the stamp duty and registration under Transfer of Property Act and Registration Act. That is a different aspect. So, women were entitled to or given only performance of the marriage by spending the amount from the co-personary. Second one is, some families used to give the traditional gifts like Pasupu Kunkuma. Third one is, women were given the maintenance from out of the assets of the co-personary. Except that in Mitakshara form, nothing was there for the women. Then come to Dayabhaga. What is it? Dayabhaga, as our friend put it, it was prevailing in mostly in what you call Bengal and Assam. It was altogether a different format. There is nothing like co-personary. The last male ancestor who was possessing the property, both his individual and the property which he obtained on division with his brothers or father, he was the monarch. He was under the control of that property. He could utilize it the way he liked. He could have alienated or spent it whatever manner he liked. His children, particularly the males, could not have questioned him during his lifetime. Whatever left by him after his death, his sons used to take it. This was the system under Dayabhaga. And in both these systems, if you keenly observe, Mitakshara was regarded as unobstructed heritage. Rather, Dayabhaga was regarded as obstructed heritage. Apratibandhaka, pratibandhaka. Apratibandhaka is unobstructed because in Mitakshara system, a person being born as a male member was enough to confer him certain right. Is not it? But in Dayabhaga, so there was no obstruction there. It is only when partition takes place you will get. But in Dayabhaga, it was a pratibandhaka. There was an obstruction in the form of the last holder of the property, last ancestor of the property. During his lifetime, none could have claimed or demanded anything. Therefore, his presence is in an obstruction to him. That is why it was regarded as pratibandhaka, obstructive type of heritage. These are the main differences between Mitakshara and Dayabhaga. We were in pre-1956 system. In both the systems, the women were getting nothing. This is the fundamental aspect. This is how the partitions used to take place. Then slowly we have to migrate to 1956. Before that, there is another enactment. There was another enactment. Of course, nowadays, because of the transition, we are around now in 2025, and even 1956 enactment is a too old an act, rather around 70 years old. Therefore, prior to that, what enactment was there, probably you may not be required to deal with it, but you have to know it for academic purpose. Or sometimes, very rarely, you may come across any case on that aspect. What is that one? That also you have to know it. This is, as I told, that when even under Mitakshara and Dayabhaga, women was not given any prominent place or share. So some justice has to be done to her. This was considered. But it was the personal law of a community, Hindu community. Even the British rulers did not want to touch it. They never touched the personal laws. Neither Hindus nor Muslims nor even Christians or other communities. So we are now concerned with Hindus. But by 1940, the injustice done to the women was so rampant that they considered it required to do some justice to the women. Therefore, and Hindu personal laws needed to be amended, needed to be codified rather. Therefore, a committee was appointed in 1941, Hindu Code Bill Committee. Is not it? You won't get in regular textbooks. You have to read from internet and all this Indian history, freedom history and all this, you will find it. A committee was appointed headed by B.N. Rao, P. Narasimha Rao, Benegal Narasimha Rao, a genius of his kind, who also acted as constitutional advisor to the drafting committee and constituent assembly in the latter years, 1946. Who roamed the entire world with the team and brought important facets of different constitutions of the world. Due process of law under Article 21, is not it? From German and American constituencies, his team visited and studied and brought that concept and placed before the Constituent Assembly, and ultimately drafting committee accepted it, and under Article 21, no person shall be deprived of life and personal liberty except according to the procedure established. There it was due process, where we have amended it and introduced in the form of shall not be denied right, life and liberty except according to the procedure established by law. So this B.N. Rao committee was also prior to the Constitutional Committee. He was appointed and he was given a team to study the personal law of Hindus and suggest codifications. From 1941 to 44, this committee has studied vigorously what are the various manners in which the women, Hindu women, were suffering. One such aspect is polygamy was prevailing at the time, isn't it? A male person could have married before 1946, I am telling, could have married more than one woman. That was not a punishable one. I mean, not custom-wise, it was not treated as a ground for divorce also, because even Hindu Marriage Act was not formed at that time. Similarly, a widow was not permitted usually to take in adoption. This is one more anomaly, they thought, this committee. And most importantly, so far as partition is concerned, women was not given a share at all. Hindu women was not given a share at all. So they thought that certain anomalies should be eradicated and statutes should be made. They have prepared what we are now seeing in the personal codes, 4 enactments, isn't it? Hindu Marriage Act 1955, 1956 Hindu Succession Act, Hindu Adoption and Maintenance Act, Hindu Minority and Guardianships Act. All these were the result of the hard work performed by the committee, B.N. Rao committee. They placed it before the settled government. In the meanwhile, freedom has come. It took some more time. The greats like Ambedkar, who was the first law minister, has proposed to introduce the code bills. But it also took some time, and slowly from in between 1955 and 56, these 4 enactments have come. That is how the Indian woman, I am visualizing the partition firstly in the context of a woman, because she had not been getting anything, she got something. That I wanted to tell you. So 1956 enactment was done, but in between there was another enactment through which a partial justice was done to women, though full justice was not done. Even by 1956 also, no full justice was done to her. That is a different aspect. Mitakshara and Dayabhaga system too, we transformed up to 1937 states. 1937, to do some justice to women, they introduced Hindu Women's Right to Property Act. Most of the juniors might not have come across because they didn't have that necessity or opportunity. But we in our practicing days used to get around 30 or 40 years back. What is this Hindu Women's Right to Property Act 1937? They wanted to do a justice to the entire women as a community, but a partial justice could be done by virtue of this enactment. What is it? 1937 enactment. Hindu Women's Right to Property Act. What this enactment is? It consists of only 4 sections. Hitherto, nothing was given to women, we studied, but by virtue of this enactment, particularly section 3, section 2 is only consisting of 4 sections, out of which section 3 is the main one. It says that a male person was having, so far as Dayabhaga school is concerned, a male person of Dayabhaga having property in his hands and died, then his sons used to take it. Therefore, a slight amendment was made. So far as his share is concerned, that would devolve on his widow. So, widow was given some share of her husband, so far as Dayabhaga is concerned. Coming to Mitakshara. Mitakshara is concerned, again we have 2 types of property. One is the personal property of a male and his share in the co-personary. In both of them, again they said that so far as his share in the co-personary is concerned, along with the sons, she also would get equal share left by her husband. So far as the self-acquired property also concerned, this is the same principle. So, what her husband used to have in a particular property, in a lighter vein I'm telling, that was conferred on her. You might have thought that if that was the case, she must feel happy. No, it is subjected to subsection 3. Subsection 3 says that what all given under the above 2 subsections was only a limited estate. Is not it? A limited estate means it was given for her life enjoyment without the right to have any alienation. She could enjoy it during her lifetime, but except that it was not her absolute property. She could not have treated it as her absolute property. But hither and there, some decisions you may come across if you wanted to peruse Privy Council decisions and others. For her ailments, means necessity for hospitalization or medicines, etc., or performing the pilgrimage, she could have alienated a part of her estate and she could have gained money. It is only an exception, but generally she didn't have a right to alienate the property. It was purely a life estate. After her death, again it would revert back to in Hindu Mitakshara, it was a co-partners. In the Dayabhaga, it reverted on her sons. Again in the process, neither woman was given a full estate, full right, nor the daughter is considered under Hindu Women's Right to Property Act. Understood? Daughter is nowhere spoken about, even under 1937 Act. Only women, that is a widow, was given a life estate. That is why it was called as Hindu Women's Estate. If you carefully see, 1956 Act, particularly section 14 of the Hindu Succession Act, it was specifically laid down in section 14.1 that what all she got it, and she was in possession by the time Hindu Succession Act came into force, that estate is transformed into a full estate or absolute estate. Am I right? So what she got under 1937, and if she preserved it and she was alive as on the date of the Hindu Succession Act, if she was in possession as on that date, then it would be converted into a full estate or absolute estate. This is after 1956 came. But at the stage of 1937, a widow was given a limited estate in respect of her husband's share. It was the concept. But again I am telling and repeating it, women as a daughter woman as a sister was not given anything, either under Mitakshara, under 1937 enactment. Then we have shifted to 1956 days. So, friends, I was making a demarcation at the beginning that who were entitled to seek for partition prior to 1956. Obviously, before 1937, it was the male members of the co-personary. And in Dayabhaga, only sons. Women folk were nowhere in this scene. Even after 1937, woman as a widow could get a life estate, though she can claim partition, no doubt. She was given a right to seek for partition, but what she could get is only by way of a limited estate. Am I right? Then we have to go to 1956 days, a transformation into 1956. That means who are the persons who are entitled to seek partition after 1956. For that you have to see what is 1956 enactment. 1956, you know, by virtue of Hindu Code Bill was studied, Hindu personal law was studied and divided into 4 different codes, one of which is Hindu Succession Act. Some justice was done not only to a widow, but women as a whole. That means daughter also. Is not it? Even sister also, she will come of course as a class to her, that is different. But women plight was ameliorated to a major extent, though not full extent. What is it? Of the entire 1956 enactment, in the women's angle, we need to see section 6, is not it? What is section 6? Any of you? Devolution of interest, isn't it? Yes. If a male Hindu having an interest in the Mitakshara co-personary died intestate, then generally his share used to devolve on by virtue of right of survivorship. Survivorship was not totally taken. For present purpose it was kept in. If he had no wife or other children, usually sons, and it devolves on co-personary and co-personers will share it. That is one aspect. But it has a proviso to section 6. This is most important. After 1956, who are entitled to seek for partition? If we put a question, the proviso will give some important answer, provided that that male person who died left behind female heirs in class 1 or male heirs in that class who are claiming through the female, then his share will not devolve by virtue of right of survivorship, but on right of succession. These persons specified in the class 1 will take his interest. This is what the first time in 1956 it was introduced. I will give an example. It does not mean that you do not know, but for your easy comprehension. Prior to 1956, if a male person, suppose a family having father and 2 brothers, the second brother died prior to 1956. The second brother having 2 sons and a daughter and wife, his notional share of 1/3 would have been devolved on his remaining 2 sons only, being the co-partners so far as his class is concerned. His wife and daughter would not have got anything. This was prior to 1956. But after 1956, some justification or some justice is done to the women as a wife as well as daughter, that they were put in class 1 heirs, isn't it? So his share, first of all, to be determined, a notional partition has to be introduced, because the explanation to section 6 consists of notional partition. So, first of all, his 1/3 share is to be divided between his 2 sons and him. That means 1/9 each. Isn't it? His 1/9 share again to be divided between his wife, daughter and 2 sons. So what the women were ultimately getting, not as a full ownership over the co-personary in its entirety, like after 2005 amendment, only from his share, they used to succeed being class 1 heirs. Class 1 heirs, if you find it, if you read it, you will say daughter, son, wife, mother, daughter of a predeceased daughter, son of a predeceased daughter, so on, isn't it? So daughter and wife, daughter and mother and wife were also included in the class 1 heirs. By virtue of it, they were getting some share, but not equal share. So far as daughter is concerned, daughter-centric question if we put, daughter was not getting full share like that of a son. It's not it. It's only from father's share, along with her brother, mother, she used to get. This is what the system was in 1956. Down to 2005, it is only in 2005 that she was regarded a Hindu co-personary property, I mean Hindu joint family, Mitakshara Hindu joint family, in a Mitakshara Hindu joint family, on and from the date of Hindu Succession Amendment Act, that is from 2005. A daughter, three characteristics features were given. A daughter shall have a right in the co-personary like that of a son. Then she shall be having, of course, all the incidents of rights and liabilities also, if at all any attached to the co-personary like that of a son, she will be entitled to a full share that of a son, and any liabilities are already attached to it, it will also be attached to her. So a full share is given to her is only from 2005. Of course, state of Andhra Pradesh is concerned, for your convenience, it was introduced, the system was introduced way back in 1986 itself. Act 5 of 1917, if I am right. From 5/9/1985, is not it?
Yes, sir.
It was introduced for the first time in the entire country. It was only the Andhra Pradesh, followed by the Punjab and Tamil Nadu, if I am right, Maharashtra also. Some states also followed this system. But as a whole, in the entire Hindu Succession Act, this system was introduced around 2005. Okay, these are the. So when we see who are entitled to partition, the first phase prior to 1937, it was only male members. 1937, widow was introduced with a limited right. Then after 1956, okay, daughter was introduced but not as a full-fledged co-personal, only to get a share in the father's share. But only in 2005 she was getting from then onward she has been getting the full share along with the sons. This is what the two systems are concerned. Her journey, if we look into in the angle of the women, I mean most importantly the daughter. Then some important aspects which have relevancy with the present day, I mean day to day, your practical aspects, I want to discuss few and give some judgments for your convenience. Then leave it to my brother. Some important aspects, ticklish issues we may come across in the course of attending partition suits. Okay? One of them is sometimes the naturally partition suit will be filed by one or two brothers against the father and other brothers, isn't it? Naturally, the general course. Claiming that all the suit properties or plain schedule properties are the ancestral properties and in which the plaintiffs also having some share as per the facts of that case. And before filing the suit since some time prior to it, the other defendants are not rendering accounts or not cooperating with the enjoyment of the plaintiffs, etc. Some ruffles have come, therefore they filed a partition suit. General lines partition suit would be like this. The defendants, what would be the general type of defense we may come across in partition suits? If it is the defendants, sometimes one of the defense is that, yes please.
Nature of the property.
It is not only nature, some other aspects also. One of the, yes, nature of the property also they may take. It is all a factual aspect we are only visualizing. Okay? One of such defenses is that the plaintiff has already divided, they do not dispute with regard to the properties or legal relationship. The dispute is only with regard to the plaintiff has already been separated and he is enjoying his share. The properties which are now shown in the plain schedule are their properties and therefore he cannot claim any share. This is one type of plea we may come across. Then what the law says, the burden is on whom is the question, is not it? The laid down decisions, the series of decisions would say that first of all, of course, if the relationship and existence of the property is not in dispute, the burden will be on the defendant to establish that there was already a partition, is not it? Why? Because under law, the presumption is that a family, if it is claimed that it is a joint, the preliminary presumption, that is means a rebuttable presumption, you may call it, that there is, it is a joint family. The court will for the first blush agree that it is a joint family. If a person pleads that, if a defendant rather, pleads that it was already severed, then the burden will be on the defendants to establish that already there was a division to non-suit the plaintiff. This is what the number of judgments you may record, note down if you want. AR 1971 Supreme Court, from that stage onwards. AR 1971 Supreme Court 1962. Indra Narayan versus Roop Narayan. So mainly it was had, there are other decisions, but it was a prominent one at that time. So I wanted to share with you. So the person who claims that there was already partition, that person, if he is a defendant, if the plaintiff, in a case, plaintiff, whoever pleads it, he has to establish with regard to the factum of partition. This is one type of case we may come across. Sometimes we may also come across a different type of situation. Some sons or all the sons will file a suit against the father and one or two brothers also, seeking partition. This is general aspect. In that partition suit, they may also plead that so and so properties, plain schedule lo konni, or oka pratyekamaina classified properties. These properties, which were alienated by our father, not for the joint family requirement, though he was a karta, he has not alienated for the welfare of the family, but it was for the purpose of his vices. We will come across, isn't it? Therefore, those alienations cannot be recognized or valid under law. Sometimes they seek for cancellation of those said deeds and for partition. Sometimes they will ignore by way of pleadings and seek for partition. Okay, whatever it be. The situation is that the plaintiffs claim that some of the alienations made by the karta, father naturally, or brother, eldest brother who happened to be the karta, alienated those properties for his vices, means for yasna. Therefore, they should be ignored or cancellation has to be effected and partition should be made. The counterclaim naturally will be the twofold. One is the Karta may claim that what all the properties I have sold or myself have got properties where the plaintiffs cannot question them. This is one type of plea. Other type of plea is that, no, these properties no doubt are the joint family properties, but I sold them for the purpose of joint family welfare and needs, not for my vices. This may be another type. But in this type of cases, what is the law on this aspect is the question. Upon whom the burden will be is the question. The law says that, judgment law, the judicial pronouncements have given two important burdens on the plaintiffs. The burden is on the plaintiffs to say that, or establish by way of cogitable, acceptable evidence that the alienation is for illegal purposes or for vices of the father. This is one thing. Second aspect is also the purchaser who purchased those properties purchased them knowing fully well that his father was selling it not for joint family requirements, only for the purpose of his own vices. These two aspects have to be established clearly for the appreciation of the court. Otherwise, the court cannot set aside those sages or ignore those sages. This one. Specifically, it was held by the Supreme Court that it is not sufficient to prove that a father has alienated, but illegal purpose must be pleaded and proved merely because the father or the Karta has sold it for luxuries. That cannot be a ground to set aside the sale. Please understand, the luxury is different from a vice or legal purpose. Understood? Luxury is different from a vice. A father, let us say a school teacher or a small employee was there. He was the Karta, hand-to-mouth man. He was having some immovable property like a house or a land. He sold that land and purchased a car. A car for their family may happen to be a luxury, but it cannot be, in the eye of law, it cannot be stated as an illegality or for the vice of the father. So you understood the distinction between vice and luxury. If it was purely for luxury, it cannot be stated. The court said that the court cannot sit on the mind of the father to think whether it is a luxury or necessity. If it is only purely a vice or illegal purpose, then only it can be set aside. You can note down our High Court decision based on the Supreme Court judgments 2016, Volume 5, ALT 295. Palaparthi Manikyam versus Palaparthi Venkata Satyanarayana. Of course, incidentally, this judgment was given by me in the Common High Court, referring to the Supreme Court judgments on this subject. So, 2016 Volume 5, ALT, page 295, Palaparthi Manikyam versus Palaparthi Venkata Satyanarayana. In this, Supreme Court judgments are also there. It is a reported judgment, you can verify if you want. So my emphasis is that mere proving that alienation not exactly for welfare of the family is not sufficient. It should be proved to the satisfaction of the court that it is for a particular vice or illegality. That must be established. Another aspect, important one. We have seen, or we are seeing also, a son going for adoption, and adoptive son files a suit for partition against his adoptive father because his ties or relationship is severed from the natural family and established and supplanted in the adoptive family. Sometimes in such a suit, the adoptive father may claim that no, he is not my adopted son. He is only a foster for some time because we didn't have the children. We brought our relations or our servants' child and we educated them, but we have not adopted them. This may be one type of plea. In such a case, obviously, the burden lies on the plaintiff to first of all establish the adoption, and also secondary aspect depending upon the factual, whether the properties are there or not, whether he is entitled to properties, a share, these aspects. So basically, if the adoption is denied, the primary burden is on the plaintiffs to establish his case. This is not a difficult one. Sometimes we will come across another ticklish issue. A boy goes in, boy or girl, whatever, boy, let us take. A girl now by virtue of 2005 amendment also. A boy goes in adoption to another family and files a suit for partition in respect of the properties in his natural family. Have you ever come across such a situation? Try to, pardon?
He will not have any rights in the land.
Yes. The question is whether he could have claimed a share in the co-personary, erstwhile co-personary or co-personary of his erstwhile natural family. This is. But what is interesting is, in what context such a claim is put, what are the different, in what manner different high courts have dealt with this issue, particularly our high court, I mean common high court. Section 12 of Hindu Adoption and Maintenance Act is very important in this regard to decide whether he could have claimed a right in his natural family as a co-partner. Section 12 says that, plainly it says that with the adoption, all his relationship will be severed from the natural family and established in the adoptive family. This is one thing. But it has an exception in the form of subsection 2. 2 exceptions are there. One of such first exception is section 12, I am saying. The adoptive person cannot marry a person whom he could not have married had there been no adoption. అంటే ఒక బాయ్ ఉంటాడు, అతను అడాప్షన్ అయి వెళ్ళిపోతాడు. న్యాచురల్ ఫ్యామిలీలో ఉండగా ఒక అమ్మాయి అతని చెల్లెలు అవుతుంది, అక్కయ్య అవుతుంది. Merely because it was an adoption, he cannot even also now marry, because that prohibited degree of relationship continues. It's a morality and other aspects are involved in. This is first exception. The second one is, that is most relevant for us. A property is vested in him, a right vested in him cannot be divested by virtue of this adoption. Once vested, it cannot be divested. This, the adoptive boy wanted to take advantage of. Once vested means, while I was in my natural family, I was a co-partner. Subsequently, I was given adoption. That co-partner right is a vested right which cannot be divested merely because I was given in adoption. Therefore, I will get two rights. One is natural family, another is adoptive family. This is the line of argument. But most of the courts, high courts, taking a cue from the Supreme Court directly on this aspect has not pronounced, but incidentally held in a decision that with the adoption, all his relationships, not specifically in the context of claiming partition, it was not that decision. But in a general context, it was observed by the Supreme Court that with the adoption, all his relationships which were there in the natural family will be severed and established in the adoptive family. Taking a cue from that judgment, the judgment for your appreciation, I may give it. Manu SC, Manu decision, Manu Patra decision only I got it. Manu SC 0296/1969. Srimati Sitabai versus Ramchandra. In this decision, they held that with adoption, all his ties or relationship with the natural family will be severed and established or rooted in the adoptive family. Taking a cue from it and also interpreting section 12B, subsection B of subsection 2, various high courts held that a right in the co-personary is not a vested right. This is most important observation. Bombay, Karnataka, Madhya Pradesh, and some other high courts, I will give you a few judgments. They have regarded that what is the right in the co-personary? You being a member of the co-personal, you will right is to have a joint enjoyment along with other co-personals. This joint enjoyment is a fluctuating interest. With the increase in the births, your right will be diminished. With the deaths, it may go up. So you cannot claim any definite share till actual partition takes place. It's not it. And furthermore, Karta could have alienated for the welfare of the joint family. Or family itself by an understanding can alienate the properties. So it all depends upon so many ifs and buts. Therefore, that right in the co-personality cannot be claimed as a vested right in the joint, in the co-personality. If that is not a vested right, if we cannot treat it as a vested right, the question of it being not divested under subsection 2b does not arise. That means with the adoption you lost all your rights in the natural family. You cannot claim, you cannot have a cake and eat it too, that is what. So you cannot claim any right in the natural family. These type of decisions.
Excuse me.
Pardon?
A small doubt.
Yeah.
Suppose in the adopted father's property, prior to his adoption itself, ancestral property was sold. Can he claim right in that property, the adopted son?
Ancestral property was sold.
Sold. Prior to his adoption, the adopted father has already sold the ancestral property. Can the adopted son question, after the adoption, can he question
Cannot. He cannot. I am first of all giving the decisions and then I may further one or two aspects governing this one I will do. One is Manu, please, any doubt or question? Manu, SC. Yes, please. At the convenience of all of us, you can give it.
One submission, sir.
Please.
1956. Age adoption from one male child. He is also eligible for the right for the original sons.
But prior to 1956,
Yeah, he adoption from the male child. Naturally, natural sons may be
so I am unable to catch up your question. Prior to 1956, a boy was given in adoption. Now?
తర్వాత వారికి మళ్ళా పిల్లలు పుట్టారండి.
ఎవరికి? అతనికి.
అతనికి మళ్ళీ ఏ బియ్యంలో ఇతర పిల్లలు పుట్టారు.
ఓకే.
ఇతర పిల్లలతో పాటు అతను కూడా ఎలిజిబిలిటీ ఉంటుందండి రైట్ ప్రాపర్టీలో.
ఏ ప్రాపర్టీలో మీరు అడుగుతున్నది?
ఫాదర్ అడాప్షన్ చేసుకున్న హిందీ సక్సెషన్ యాక్ట్లను రైట్ ఉంటుంది. పార్టీషన్
ఒక బాయ్ అడాప్షన్ వెళ్ళిపోయి 1956. ఆ తర్వాత ఎవరికి? న్యాచురల్ ఫాదర్కి చిల్డ్రన్ పుట్టారనా?
న్యాచురల్ ఫాదర్
పుట్టారు. వాళ్ళు కోపర్సనల్ కంటిన్యూ అవుతారు అంతే. ఈ అడాప్టివ్ బాయ్ వెళ్ళిపోయిన అతనికి ఏమి ఉండదు. అది అంతే.
తను కూడా రైట్ ఉంటుందేమో.
లేదు, ఉండదేమో. ఉండదని హైకోర్టు సుప్రీంకోర్టు అంటున్నారు. మీ క్వశ్చన్ సరిగా అర్థం చేసుకో ప్లీజ్ బేర్. అడాప్షన్ ఒక బాయ్ వెళ్ళిపోయాడు 1956 ముందర. తర్వాత న్యాచురల్ పేరెంట్స్ పిల్లలు పుట్టారు. ఆ పిల్లలతో 1956 అయితే ఓన్లీ మగ పిల్లలు, ఆ తండ్రి న్యాచురల్గా ఒక కోపర్సనరీ కంటిన్యూ అవుతుంది అంతే. ఈ వెళ్ళిపోయిన బాయ్ ఏ రైట్ న్యాచురల్ ఫ్యామిలీలో ఉండదనే ఇప్పుడు ఈ జడ్జిమెంట్ తాలూకా సారాంశం అన్నమాట. అది
తీసుకున్నాను సార్.
తీసుకున్నానికి మళ్ళీ
మీరు అంటున్నది అడాప్షన్ ఇచ్చిన ఆయన పుట్టారా ఎవరికి పుట్టిస్తారు? వాడు కూడా కన్సల్ట్ అవుతారు, వాడు కూడా కోపాసనతో చేస్తారు.
1/7 షేర్ ఉన్నది తప్ప 50% షేర్ లేదంటున్నారు సార్.
1/7 అని మీరు ఏదైనా పెండింగ్ కేసు గురించి చెప్తున్నారా? Example is so simple. Please, we are running short of time. My brother has to give this. See, రెండు ఎగ్జాంపుల్స్ మీరు అడిగిన ఎగ్జాంపుల్ అడిగింది కూడా చెప్తున్నాను. ఒకవేళ అడాప్షన్ ఇచ్చేసిన తర్వాత న్యాచురల్ ఫాదర్కి మదర్కి చిల్డ్రన్ పుడితే వాళ్ళు ఒక కోపాసనరీగా కాన్స్టిట్యూట్ అవుతారు, కానీ అది వాడు తెలుసుకుంటారు. ఈ వెళ్ళిపోయిన అతనికి ఏ రకమైనటువంటి రైట్ ఉంటుంది. ఇది ఈ జిస్ట్ ఆఫ్ ది డెసిషన్స్. రెండో ఎగ్జాంపుల్, అడాప్షన్ తీసుకున్న తర్వాత బై గాడ్స్ గ్రేస్ అడాప్టివ్ పేరెంట్స్కి చిల్డ్రన్ పుట్టాడు, వాళ్ళకి రైట్ ఉంటుంది, వాళ్ళ రైట్ ఎక్కడికి పోదు. అడాప్షన్ వెళ్ళిన ఆయనకి కూడా ఉంటుంది, ఆయనది తప్పు లేదు కాదు, తప్పంతా ఎవరిది లేదు. అదే
సార్ ఎన్ని జనరేషన్స్ ఉంటాయి?
ఐవీఎఫ్ ఐయుఐ అన్నీ కూడా వచ్చిన తర్వాత పిల్లలు పుట్టడం కష్టం కాదు.
Now that adopted son will inherit the properties of the second husband because of doctrine of relation back, he is the son of the ex-husband, not the next one. Right? So will he inherit the property?
ఆవిడ ఎప్పుడు అడాప్ట్ చేసుకుంటే రెండో మ్యారేజ్ చేసుకోకముందే డాక్ట్రిన్ ఆఫ్ రిలేషన్ బ్యాక్ టు వ్యూ ది లీగల్ స్టేటస్ టు దట్ బాయ్. డాక్ట్రిన్ ఆఫ్ రిలేషన్ బ్యాక్ ఎందుకన్నారు? అడాప్షన్ చేసుకున్నది ఆ భర్త బతుకున్న టైం నాటికే, అట్లీస్ట్ ఆన్ ది డేట్ ఆఫ్ డెత్ నాటికే తను ఆయన ద్వారా పుట్టినట్టు, అంటే లీగాలిటీ ఇవ్వడానికి కోసమే తప్ప ఆయన రైట్ని పోగొట్టడానికి మాత్రం కాదు. ఇవి వ్యాలిడ్ బాయ్.
First husband is ex, second husband is right, but he is son of the ex only, right? But will he inherit the properties of wife?
Certainly. He is the legal for all practical purposes. He will be.
సార్ ఎన్ని జనరేషన్స్ ఉంటే అది యాన్సెస్ట్రల్ ప్రాపర్టీ సార్? అంటే గ్రాండ్ ఫాదర్ అసెట్స్
Four generations. కామన్ ఏ, ఆయన కొడుకు బి, ఆయన కొడుకు సి, ఆయన కొడుకు డి.
ఇప్పుడు గ్రాండ్ ఫాదర్వి యాన్సెస్ట్రల్ కింద రావు కదా సార్. సో గ్రాండ్ ఫాదర్ అసెట్స్ విల్ నాట్ బి ట్రీటెడ్ బై గ్రాండ్ సన్ యాజ్ యాన్సెస్ట్రల్ ప్రాపర్టీ. మనవడికి ఆస్తి అట్లా యాన్సెస్ట్రల్గా ట్రీట్ చేయాల్సిన పని లేదు కదా సార్. అప్పుడు మనవడు గ్రాండ్ సన్ తాత ఆస్తిలో వాటా ఉంటుంది అంటుంటారు కదా.
తాత ఆస్తిలో వాటా ఉందని స్ట్రైట్ క్వశ్చన్కి మనం ఎదుగుతాం. అన్లెస్ సమ్ ఫ్యాక్ట్స్ అంటే తాతకి కొడుకుల మధ్యన ఉంటే మనవడికి రాదు, మా నాయనకి వచ్చిన దాంట్లో ఇంకొస్తుంది.
అదే సార్,
అది
అది కూడా నాయనకి వచ్చింది కూడా ఈ కెన్ క్లెయిమ్. నాయన అమ్ముకున్నాడు అనుకోండి, అప్పుడు ఈయన క్లెయిమ్ చేయాలి.
తాత దాంట్లో ఇంకొచ్చేది ఏముంటుంది? తాతది డైరెక్ట్గా రాదండి. అదే మనం తాత దగ్గర నుంచి ఆయన కొడుకులకు వస్తుంది, ఆయన కొడుకులు వచ్చిన దాంట్లో వీళ్ళ నాన్నకు వచ్చిన దాంట్లో మళ్ళీ ఈయన వీళ్ళందరికీ వస్తుంది.
వాళ్ళ నాన్న ఫ్రీగా అమ్ముకోవచ్చు ఏదైనా, అంతే. ఫాదర్ ఏమైనా అమ్ముకోవచ్చు.
ఫాదర్ ఎప్పుడు అమ్ముకోవచ్చు అంటే తాత దగ్గర నుంచి వచ్చినప్పటికీ వీడికి పిల్లలు లేకపోతే అమ్ముకోవచ్చు. పిల్లలు పుట్టక ముందే అమ్ముకుంటే అది వ్యాలిడ్. పిల్లలు పుట్టిన తర్వాత అయితే అది కోపర్సనరీ ప్రాపర్టీగా రూపాంతరం చెందుతుంది, అప్పుడు అమ్మలేడు. అమ్మితే వ్యాలిడ్ పర్పస్ కోసం అమ్మితేనే అమ్ముతుంది. అది
ఓకే సార్, థ్యాంక్ యూ.
So my request is, we are running short of time, and please don't put a question which you are doing in the form of a case, because it needs some, no, it's not a fault in asking it. Purely legal aspect మీద అయితే మనం మెయింటైన్ చేయగలం, లేకపోతే కొన్ని ఫ్యాక్ట్స్ లేకుండా కరెక్ట్గా డిస్కస్ చేయడం కుదరదు. ది కాన్సెప్ట్ హియర్ అడాప్షన్ ఏంటంటే, a adoptive boy went into the adoptive parents, whether he can claim a right in the natural family, and series of decisions which I have discussed. Manu SC into me చెప్పలేదు మరొక రెండు decisions. There we are. I will close it within 5 minutes. Manu SC 2803/2005 బసవరాజప్ప వర్సెస్ గురు బాసమ్మ. అలాగే AR 1992 బాంబే పేజ్ 189 దేవగొండ రాయగొండ పాటిల్ D.R. Patil versus S.R. Patil. All these decisions, another only one, Patna decision, AR 2001, Patna 125. And S.K. Jalal versus Chandrakishore Jalal. All these decisions are on the point that a right in the co-personal is not a vested right, they treated it. It is only a right of enjoyment till partition took place. So when you are adopted to some third party, adopted by third party, your right in the co-personal cannot be regarded as a vested right so as to claim a right. This is the fundamental aspect. Okkati. But a different type of decision was given by our own High Court. That you have to note it. AR 1981 AP, page 19. AR 1981 AP, page 19. Yarlagat Naidamma and others versus Government of AP. It is in this decision, it was held in a different manner. AR 1981 AP, page 19. In a different manner it was treated, the same problem. No, it is a vested right. A right in the co-posterity of a natural family is a vested right. It can be carried to the adoptive family also. Therefore, adoptive child can claim, adoptive son in that case, can claim a right in the original family also. Of course, I must quickly add that this opinion arrived at by a land single judge was based on the commentary of a commentator and not taken into consideration the Supreme Court judgment of 1969, wherein the Supreme Court, of course in a different context, observed that with the adoption all relations will be severed. Okay? Therefore, I leave it for your study and utilizing these decisions. I can't suggest you which decision you have to apply. But different high courts, basing on Supreme Court's earlier judgment of 69, observed that no, it is not a vested right. But AP High Court, the land single judge, observed that it is a vested right. I give it to you. One more and I will close. This is one controversial aspect. Of course, third party rights. We were dealing with the third party. Second aspect is third party right, isn't it? Third party right. Actually, prior to in 1956 case, a co-personal could not have alienated his share or any definite property in the co-personal. But all the members by an agreement could have, or with the consent of other members, he could have alienated. But without that, of his own interest, he could not have alienated it. Even after 1956, as per section 30, he could have executed what? It is a testament will, so far as his share is concerned, undivided share is concerned. This is the legal position, but in practical situation, we will come across sometimes a co-partner sometimes alienates his undivided share. Sometimes, very strangely, alienates a particular property in the co-partner for his requirements. Maybe lawful purpose, but without the consent of other co-partners, etc., he alienates it. Then what is the right of the third party purchaser is the question. The law is that third party purchaser cannot claim any right over the property, and he cannot sometimes claim joint possession along with the other co-partners also in respect of the property which he purchased. Then what is his right? His right is always for praying for equitable relief. That means he can file a partition suit requesting the court to partition the properties of the joint family and allot that property which he purchased to his vendor and then deliver that property. It is a lengthy process and purely depending upon the equity. Equity means a request type. Or already a partition suit is pending in the court, there he can join as a third party purchaser, making again the same request. That property may be, which he purchased, may be allotted to his vendor and may be allotted to him ultimately. The court may, depending upon the facts and other findings, accede to his request or it may reject his request, and his relief is against his vendor but not others. Therefore, these type of judgments we have, please take note of it, 1 or 2. AR 2008, Supreme Court, page 2489. Hardev Roy versus Shakuntala Devi. Another judgment also from Andhra Pradesh, which was AR 2009 Supreme Court 2141. Pitani Suryanarayana versus Repaka Venkata Ramana Kishore. So this is with regard to third party purchases right. Then the last one is, of course there are others, for paucity of time I cannot deal with, particularly with regard to the rights of the illegitimate children and all this. Law is settled recently, you might have come across. But one important aspect is procedural one. Third component is, in ours is, who are entitled to seek for partition prior and subsequent to 56 and 2005. That is one aspect we have discussed. Practical things. And the second one is the rights and liabilities of the third party purchaser. And third one is with regard to the final decree petitions. Hitherto, or at least till decade back, invariably all of us, even in our practicing days and even your practicing days, used to file final decree petition after a preliminary decree was passed, isn't it? Treating that, even the courts were treating it as preliminary decree, rights are defined, there ends the matter, the judge will stop the proceedings there. Again, you used to file an IA for passing of the final decree, another idea for appointment of advocate commissioner to evaluate the mean profits, so on and so forth. But the Supreme Court's observation, in the Supreme Court's concept, what the final decree petition is, it alien to the preliminary decree. The Supreme Court has observed it. For those who already know these judgments, well and good. For those who have not come across, please note them. The Supreme Court held that final decree is not an alien to the preliminary decree, and the courts, it is a court-centric judgment. The court's responsibility-centric judgment. This court's responsibility is not completed by merely passing the preliminary decree. The party who has knocked the doors of the courts has not come only to be satisfied with a preliminary decree. He wanted ultimate fruits of the decree. That means actual partition by metes and bounds and to give back his share. So in that context, he need not be asked to nudge the judge or the court again to pass a final decree by filing a final decree petition. It is the duty of the court to continue the proceedings. This is what important. The court has to continue the proceedings in the form of even after preliminary decree and complete the proceedings. This judgment was rendered in the context whether there was any limitation for filing decree petition. That aspect was also discussed by the Supreme Court twice. Please note down. Please. 2009, Volume 9 Supreme Court Cases, page 689. Shah Karan Bubna versus Sita Karan Bubna. It's only 2 sentences it was observed, but very poignantly the Supreme Court has observed. I will quote, when a preliminary decree is passed in a partition suit, the proceedings should be continued by fixing dates for further proceedings till a final decree is passed. It is the duty and function of the court. Performance of such function does not require a reminder or a nudge from the litigant. The mindset should be expedite the process of dispute resolution. So it is the duty of the court to continue the proceedings. The same judgment was again reiterated in the latest judgment 2022, Volume 7, SCR, Supreme Court Review, I suppose. SCR, page 1120. Parties not noted, sorry. 2022, volume 7, SCR, page 1120. So, if you file final degree petition or not is not the question. The court's duty is to continue the proceedings. So, in that context, one cannot say that there is any limitation for filing final degree. That aspect is also discussed. Please read for your comprehension. These are the aspects which I thought that there are few aspects, of course, you must be awaiting, but there is no time for us to discuss with regard to 2005 when the daughter can claim, if a father died even prior to 2005, whether she can claim a share or not. The law is well settled with Vinit Sharma's decision. Most of you might have known. I wanted to discuss, but there is no time. I request my brother to continue and add important aspects on this.
Thank you, sir, for your presentation on the subject. Is very informative and it is well received by all the persons who gather here. Now, presentation to the chief guest.
On behalf of the organizers and all the participants, I extend our deepest gratitude to Honorable Justice Durga Prasad Garu